My name is Ginger Lerner-Wren, and I am a Broward County Court judge. And I originally came to the bench from a protection and advocacy system background. I was working at the time for the Advocacy Center for persons with mental illnesses, which is now Florida Disability Rights. And I was selected to, in a very unusual role and position, I was asked to come to the Advocacy Center and oversee the implementation of a very unique type of consent decree on a federal class action that was impacting our state hospital in Broward County. And that particular that particular federal class action was really not geared to necessarily improving the conditions of the hospital, but it was really intended to drive the buildup of the community-based mental health system across about 5 or 6 counties, which is basically all the catchment areas of this regional hospital. And so I gained a very specialized skill set having to do with deinstitutionalization and individualized discharge planning and psychiatric rehabilitation and consumer mental health rights and disability rights. So when I ran for office, it was just a very, very opportune time. When I came to the bench and I ran for office, and that was in 1995. So it's been a long time now. It's hard to believe, actually. But in Broward County, Broward County was experiencing a number of different problems with regards to their local criminal justice system and the issue of people with mental illnesses that were being arrested. And we were experiencing, for example, jail overcrowding, and there was a grand jury investigation of our community-based system of care, which in 1994, the grand jury issued a scathing grand jury report about really the fact that Broward County had absolutely no continuum of care, that our community system of care was broken, it was leaderless, and it was driving individuals into our jail system. So a task force was created, a criminal justice mental health task force led by one of our circuit judges, and we have a very highly charismatic public defender named Howard Finkelstein. And at the time, Howard was representing a defendant by the name of Winn. And Broward's mental health court really is a legacy to Winn, because Aaron ended up being diagnosed with schizophrenia. He had experienced a traumatic brain injury from a motorcycle accident, tragically, when he was 18 years old, just getting ready to go to college. And the case that Howard was assigned to evolved when Aaron's family couldn't find any services or treatment for him in the community. And one day, while going to one of our major grocery store chains here, had a negative reaction while checking out at the cashier, and ran out of the store and collided with an elderly woman who tragically died. And sure enough, Winn was now being charged with murder. And it was Howard that spearheaded the grand jury investigation, and ultimately it was Howard, through the task force process, that thought that a specialized mental health court would be able to marshal scarce resources and be able to work towards decriminalizing, the individuals coming through our system. And I don't know if he actually had a clear vision how the court would be designed, but he certainly had a belief that now that I was coming to the bench, that there would be a judge who would be able to match some very unique technologies and skill sets with the need that our community had. And that's really the birth of the mental health court. We really didn't have any money. We had no grants. We, to this day, don't get any grants. And yet we had a tremendous shared vision of our community-based treatment providers that we had to do something. And the Broward County Mental Health Court was our something. Because, you know, there's so many varied, diverse models of the mental health court now, which really don't necessarily reflect, you know, our values and our human rights framework. That Broward's misdemeanor mental health court was really looking to deliver and provide to the people that we were serving. And first of all, we understood that the individuals that we were going to be, you know, seeing in the mental health court, number one, that the vast majority of these individuals were just endlessly revolving through the streets if they were homeless, revolving through the jails, revolving back into the streets, then maybe into an emergency room, maybe into a psychiatric acute care facility, out back into the streets. Why? Because we don't have enough services. And the access to treatment, you know, is a terrific, massive problem here. And so the idea is that if we could, in one centralized area, have a court that would, for example, elevate the notion that we know that treatment works, elevate and communicate the notion that we know that you are not your symptoms, and we believe that, you know, you could live your dreams, you could live your best life, and so dignity, the reduction of stigma, the idea that we could actually, you know, work to take individuals from an inappropriate system of care, meaning a jail system, because that's not a system of care, and use the court essentially as a structural funnel, as a corridor, as a pathway from one inappropriate system and getting individuals, if you will, to a more appropriate system of care, and then work with that individual to see what can we do for you. And in other words, really, I think through a therapeutic jurisprudent model, be able to give voice to the person and say, look, we're here for you. It really, I think, was, at the beginning, very shocking, you know, for individuals in the criminal justice system, for example, to think that a court, that a judge, you know, was willing to actually put the individuals that we were serving ahead of the traditional view of what a judge should be doing. But we really had a very, very clear vision of the needs of the individuals that we were serving, and the fact that even, because this court is purely voluntary, that even if an individual, for example, was not interested, correct, in participating in this court, that at the very least we can deliver personhood. And personhood for the court process, I think, was a really one of the fidelities that I think is clearly one of the most paramount to the court, because what we found and what we recognized very, very clearly is when we were able through a therapeutic voice to connect with individuals and really understand the suffering and the importance of dignity, that individuals would trust us, that procedural justice piece was really a critical factor in helping to link individuals to the type of services and treatment that they really needed. Well, what we realized is there was an urgency, that there was an extreme, we wanted to set and establish, I think, very clearly that if we were going to do this, that if our community was interested in changing the way we were doing business, that we no longer wanted to be part of a system where we were just kind of like blindly going along, just another cog in a wheel, that, we would just, move people blindly into the criminal justice system, then we really needed to do something, I think, very different. And so we decided that we would do all the clinical triaging right in the courtroom, and that all of the challenges, all of the tragedy, all of the joy, when individuals got the kind of help and services they needed, that everybody could see and experience what we needed to experience, correct? With regards to this population and these challenges, these vexing social challenges. We really didn't want to waste time, and so the court ultimately did get funding for a clinician in the courtroom. I was very fortunate that while I was doing my federal class action work at the state hospital, I identified somebody that ultimately would come available to serve as our clinician. Janice Blendon, a licensed clinical social worker, is incredible, a psychiatric, rehabilitative expert from a person-centered choice vantage point. She's been with us now for over, now into the 18th year. And we really decided that we didn't want people staying in jail for 1 minute longer than they had to. So the triage, we really converted the courtroom almost to like a MASH unit. And if we had emergencies, I don't have any legal authority to do any commitments, to do any involuntary civil commitment orders. But what I do have authority to do is I have authority to sign what we constructed as an emergency transportation order, basically just saying, we have a clinical recommendation that this individual may need emergency acute care in a hospital. And that's where the diversion, that's one example of a diversion, where the individual would leave the inappropriate jail system and get to a local acute care facility or hospital, and then they would go through an independent clinical review, which I thought from a therapeutic vantage point was very, very important, meaning that I'm wearing only one hat, that I'm not doing the commitment, that's being done independently. The order also provided that no individual could be returned or discharged back into the jail system without coming to me first. And that way, if an individual, for example, does not have a criminal history, does not pose any public safety risk, for example, this is one of the easiest examples I can use, that they have a place to live, that whether they're interested in care or not interested in care, I'm going to go ahead and get that person out of the criminal justice system. So from a diversionary vantage point, and there's everybody kind of maybe has a unique situation, so it's hard to cover every single example, but I can say that certainly that our overarching principles is that public safety, of course, is always paramount to everything, but that we are most interested in not tethering individuals to the criminal justice system unnecessarily. And that is based on a number of grounds, both from a due process vantage point, but also on a human rights vantage point, meaning that our fundamental belief is that if our community was well developed and had a full array of mental health outpatient centers and drop-in centers and services and supportive services and housing, then these individuals would not be coming into our criminal justice system inappropriately. And so if we really use the court then to help deliver that, to help create that through the expert staff that we have, and all of us bring a certain amount of psychiatric rehabilitation expertise to the court process, and through, again, an amazing therapeutic jurisprudence, law reform model, we are able to get these individuals out of the jail system swiftly, and we're able to do it humanely, and we're able to do it with dignity. Sure, absolutely. I think it's important, particularly for communities that are thinking about establishing a mental health court. My recommendation always is start with your lower level offenses. Why? Because you're trying to work with individuals that give you the most flexibility for diversion, that your assessment of risk, always needs to be done. And you really are trying, I think, at least our view, was that we want to maximize the work of the court in the best way we can. And that is that we want to help people access scarce resources and really do some terrific treatment matching through the court process, really almost using the court process as a healthcare navigator. And so in that sense, quality of life offenses, nuisance offenses, the minor offenses, I think gives mental health courts and communities what I consider to be, the biggest bang for the buck, so to speak, because those are the individuals that will not escalate into the criminal justice system. Those are individuals that, you won't hopefully be seeing again. And so in the beginning, we were piloting, and the pilot numbers were small. They grew certainly over time. It's always good, to start small when you're piloting. But we see now, I think after like the first year or so, we started seeing about maybe 1,500 individuals through the mental health court a year. And we are now moving into our 19th year. And our mental health court is part-time. I'm also responsible for a regular, full criminal division. And in that part-time voluntary court that gets, no funding, we've diverted over 18,000 people out of our local jail system. And we've been evaluated, studied by the University of South Florida Mental Health Institute. We went through multi-year studies with them, and we found two very important things. One, that when you use a human rights framework, when you use a therapeutic model, when you don't overburden people with conditions that people with disabilities, for example, we know aren't necessarily going to be able to manage, that's only going to drive increased recidivism, correct? That if you understand the needs of the population you're dealing with, and you design your court, not like a drug court, not like some, traditional court process that's adding a mental health component. When you really design a court in alignment with the goals that you're trying to create, and you don't overburden people, but you do what you need to do on a highly individualized level with precision, putting public safety above, correct? Everything. You get some really wonderful, wonderful outcomes because you're working in partnership And mostly, I think the conveyance of empathy, the ability for individuals to tell their stories, that communication, that we care about you, that we want you to live your best life, that, you know, we have an unqualified, abiding belief in recovery, correct? That vision is so incredibly transformative, that we all transform. I mean, all of us, every single day. And it doesn't mean that there's not incredible moments even today. I mean, you know, we had tremendous challenges in the courtroom this morning, but that's because an individual came to court and she couldn't get her benefits. She had no Medicaid. I mean, for example, the state of Florida is 49th in funding, and I know you know that, you know, we don't have Medicaid expansion, that we have 1 million individuals in the state that don't have access to health care, and individuals don't have enough money to buy food. And a woman, she wasn't even in my court, came to the courtroom to get help. And that tells us, you know, a lot, that they trust people to know of us, they trust the court to help, and we did. And so, you know, but it was a tough morning this morning in court. It was painful, and yet we know that with connection to community care, to the right kinds of, you know, compassionate supports, with the right precision of what's needed, you know, she's going to be fine. And that's our experience. And it's very challenging when policymakers, you know, won't, for whatever reason, be open and embrace the truths, you know, the profound truths that mental illness is no different than any other, you know, kind of medical problem. And yes, you know, there are individuals that may have more serious conditions than others, we know this, but that the vast majority of people with the right kind of medical care, you know, manage their conditions like anybody else with, you know, with diabetes or with high blood pressure or anything. And to deny, you know, Americans, you know, the opportunity for care, you know, to me is just unconscionable. And, you know, and I really believe that, you know, all of this wasted money that our, you know, states and communities are spending on this constant recycling of people, if we can just get some sound policy in place, millions and millions of dollars could be invested in the type of community care and excellence that Americans deserve. You know, first of all, Broward's mental health court in 2000 was the model for the National Mental Health Court Demonstration Act that Congress passed and President Clinton signed just before he left office in 2000. And the truth of the matter is there's hundreds of mental health courts around the country, and Florida right now in this state is passing legislation to standardize mental health courts in the state of Florida. So the model actually is very popular. It's a very popular model, and you know, I think that's positive, and I also think it's not so positive. And I think it's positive because remembering, going back to the history, that Broward County, where the first mental health court, you know, was pioneered almost 20 years ago, we didn't have any funding. We couldn't start a community-based program, or we didn't have policymakers that had the will to do that. The idea of finding solutions was coming out of the criminal justice system, because it was the criminal justice system that was standing up to say, and waving the flag to say, you know, we're having a problem. We perceive this criminalization of people with mental illnesses as a big problem. We're starting to really, you know, see a jail overcrowding problem. There were suicides in a couple of suicides tragically in our jail. We had the Winn case. We had judges that weren't trained. We had individuals that were coming into courtrooms and they were in psychotic, having psychotic types of symptoms, and judges would misinterpret, you know, individuals not being able to behave or be appropriate in court, and they would hold them in contempt, not understanding what they were seeing. You had state attorneys that were just supervisors and public defenders that were running around the courthouse in chaos, from courtroom to courtroom to courtroom, when judges would say, we need help. We don't know what to do. And so the idea of creating the court was really a stopgap measure. It was really an innovation that was not even thought about as possibly being institutionalized or expanded. This was just the only thing we can do because we didn't have any money in Broward County. We didn't have a sheriff, for example, in Broward County at the time that would consider doing some kind of a specialized, you know, CIT policing program. So the court-based model then was the only solution that a task force that was at this point meeting for several years came up with from a consensus vantage point. Having said that, I would say, oh my gosh, we had no idea, none, that our court process would work. I hoped it would work. I kind of brought the deinstitutionalized technologies and skills that I had learned from some of our nation's greatest experts that were part of our expert team in the litigation that I was involved in. I transported that into the court system. But at the time, I remember thinking that at the very least, the court would be a gift, that it would be a gift to our local Broward County NAMI families, because they were losing their children, their adult children, to the jail system. They were getting enmeshed in the criminal justice system, and I thought, you know, at the very least, the court would be a symbol. I mean this, that we would show our community families who were in crisis that you had a judge. You had a judge that got it, that understood that the criminalization of people with mental illnesses was absolutely unacceptable, and that in Broward we were going to do something. And the court was going to be that something. As I said before, the good news is that the technologies, the fidelities that were very, very carefully designed to match the needs of this population, of the people that desperately needed our help, coming from a human rights perspective, that we got terrific outcomes. That's true. But our real intention was not necessarily to see the model duplicated. We didn't want that. Our intention was to demonstrate the significant need, the unmet need in our community to our local and state and national policymakers, number one, and to also show that recovery is possible and treatment works, meaning that our intention was that we were hoping that policymakers, and we were seeing policymakers, delegations were flying in from all over the United States, from all over the world, experts in psychology and mental health and academics and judges and criminal justice experts, and we were really, really hoping that a public health approach would actually emerge from the plight that people were witnessing in the court. And I think that the good news is that when Congress passed the legislation and funded other mental health courts, yes, that's good. Mental health courts are a great tool. We think they're a terrific tool to push against the criminalization, to offer treatment over jail. Absolutely. But our real intention was to drive the public health, mental health, behavioral health funding in the community so we can prevent individuals from becoming criminalized, that we could break, these endless arrest cycles, that we can create, a well-being model, of wellness, in our community. And unfortunately, instead, one can say, well, Judge, the mental health court model is, really gaining a tremendous amount of traction. And I would say, well, that's true. I said, but that was not our intention. And our intent is, and it will always be, that we have to fund mental health care, behavioral health care in an integrated fashion in the community, that this is about access, health equity, and parity, and that this is where the real emphasis needs to be. And I really have hope. If I don't, I think one thing that has been sustaining over the last 18 years has been the incredible experience of witnessing individuals that at one point were sitting in jail in handcuffs and then coming back, later, and they went back to college and they went back to their jobs and they found, love, and they're in relationships and they are living, their best life just like the rest of us, correct? And I feel that that optimism, that vision, that, we stand on, a moment, for example, where I actually believe that legislation that was passed, for example, in 2014, the Excellence in Mental Health Care Act, is a game changer. That they have policymakers who really, really understand the significance of developing a prevention-oriented type of behavioral health care community system, is funding certified community clinics, mental health centers that can respond to crisis, that are recovery-focused, that uses peer specialists as part of their established array of services, that appreciates choice, that is compassionate, and that creates the type of availability and system and behavioral health care integration that it not only deals with the mental health side, but of course also brings in the substance use and the addictive disorders. And together, in an integrated care system, through the Excellence in Mental Health Care Act, I believe that we're going to see a huge shift in what's happened in the United States, and that this will, finally, I begin to see an end to the criminalization of people with mental illness. I can't think of any other kind of physical illness where an American is jailed. You get diagnosed with cancer, you go to a doctor, you have, an emergency cardiac episode, an ambulance comes, not a police officer. Healthcare workers come, and you go to a hospital. That families don't need to wait in desperation trying to find treatment in their cities, in their counties, for individuals that need medical care. We're talking medical care. And the idea, that there are policymakers who know, that access to care requires some financial pathway, and yet denies that to an American. People who are working, people, who have a birthright of citizenship, people that have, that but for disabilities, which can be mitigated, which can be managed. We really, I think, need leadership that understands that the barriers to mental health are very much, I think, akin, not the same by any stretch, but that the urgency is not unlike what we saw, in the 80s, in the early 80s, when the HIV/AIDS crisis was emerging and nobody would help. And nobody would help. We all need to stand up. We all need to understand that mental health is essential to all health, that it's 1 in 4 individuals in a lifetime, over a lifetime, will experience some kind of mental illness. So what? So what? It's treatable. And, this consciousness, really starts with leadership. And I think that when we get that kind of leadership, and it needs to develop like a contagion, that we need champions. We need champions on every single level of government. We need it in the public sector. We need it in the private sector. We need to be able to integrate suicide prevention, as a major, major priority, as a platform, so that we could end suicides, in the United States, so we could help our veterans, so we could prevent tragedy. We can do this. We're doing it. And I think that leadership is a huge issue. The other, aspect, I think, of accountability is to ask the question, what are we being accountable to, and who is the one that needs to be held accountable? And accountable for what? So if the social vexing problem is the failure of policymakers to adequately fund and, fulfill the vision, for example, that President Kennedy had in 1963 with the Community Mental Health Act, if that is the social policy vacuum that we need to fulfill, then we need to fulfill that. And the U.S. Supreme Court gave us a gift. They gave us a gift that was intended to strengthen the Americans with Disabilities Act. And that gift has a name, and it's called Olmstead. And Olmstead says very clearly that policymakers on every level of government under the Americans with Disability Act, Title II, that public entities have a duty. They have a duty to stand, to policy make against discrimination, against social isolation of disability. And for some reason, the Americans with Disabilities Act has not been enthusiastically or aggressively or embraced for people with psychiatric disorders. But Olmstead, written by, Justice Ginsburg, tells us it applies to people with mental illnesses. And so community is supposed to be a priority. The funding of community-based system of care under Olmstead, the law says, this is what we're supposed to be doing. And yet, nobody talks about Olmstead. They wait for the Department of Justice, for example, to file some, major federal litigation, but Olmstead is an individual right. Olmstead is in the community. Our county commissioners, our city councils, our state legislators, all are supposed to be complying with Olmstead. And I think, looking back, if the mental health court, for example, had been started after Olmstead in Broward had been created, then we would have used Olmstead as a major value system. That we would, everything we do would have been from an Olmstead, and we would have said, Olmstead, we are enforcing Olmstead by doing X. And we would have been so proud of complying with the law in a way that prevents discrimination. And so I think that we need to refresh ourselves and re-educate ourselves and remind our communities that we have a gift. And that gift is called Olmstead, and we need to open that gift. And we need to embrace it, because not only is it the right thing to do, not only will it help drive community-based excellence in behavioral health care and services and supports and housing, but it's the law. It's the law. And I think that we need to have a second coming, a second wave of really championing Olmstead and helping people understand, what it means, what the responsibilities of local and state and national policymakers are under the Olmstead framework, and that people should feel really great about championing the law because it could end criminalization. I mean, people have the ability to impact justice, I think, in such a profound way. And they're really not taking that opportunity to leave a legacy in their lifetime.